All right. Hello, everyone. Welcome to today's webinar, our last webinar of 2024. Today, we're going to be talking about embracing the future of Medicare Secondary Payer. I'm Heather Sanderson. I'm the founder and CEO of Sanderson Firm. Just a little bit about myself. I've been in the MSP industry for close to 20 years now. Before starting Sanderson Firm about 4 years ago, I worked for several major Medicare Secondary Payer vendors in the space. Most recently, I was the chief legal officer for a company named Franco Signor. They were acquired by Verisk or ISO Claims Partners in 2020, and that's when I started Sanderson Firm, and we are a nationwide provider of Medicare Secondary Payer services. What makes us unique is that we are a law firm. We do have attorneys on staff, and we're able to consult, and our services range from Medicare set-asides to Section 111 reporting, to conditional payments, as well as the legal consulting piece. We've grown extremely rapidly in just 4 years, and we are grateful to be working with some of the nation's largest insurance carriers, self-insured entities, TPAs, and governmental entities that need assistance in Medicare secondary payer compliance in workers' compensation, no fault and liability claims with Medicare beneficiaries. I'm going to turn it over now to Brendon to introduce himself. Then I'm going to go through some brief housekeeping items, and then we'll go ahead and get started.
Thanks, Heather. So hello, everyone. Good morning, good afternoon from wherever you're listening in from. Thank you for joining us today. My name is Brendon De Souza. I am the Chief Legal Officer here at Sanderson Firm. I've been in the Medicare Secondary Payer space for about 7 or 8 years now. I started at a company which Heather just mentioned, Franco Signor. While I was at Franco Signor, I worked directly up under Heather, where I learned everything about from handling conditional payments, appropriate Medicare set-aside drafting, Section 111 reporting compliance. I even went to Capitol Hill, as Heather did, to speak on the PAID Act, and we were successful in getting that passed. So lots of interesting things. 2024 was a big year, lots of changes made to MSP. 2025 is shaping up to be the same. So thank you all just for joining us, and definitely you're going to take some good information out of this presentation today.
For sure, no doubt. And I think that's why we came up with the title of Embracing the Future of MSP, right, Brendon? Because 2024 was so active with MSP initiatives from CMS, and we anticipate 2025 and beyond is going to be just that. So we all need to embrace it, right? We need to learn what are some best practices, what are the things on the horizon that you need to know. And that's the purpose behind today's webinar. We're going to talk about the current landscape as it sits at the end of 2024 for MSP compliance, as well as talk to you about some future predictions. Well, let's go ahead and get started because we've got a lot to talk about. We are going to cover the ever important civil money penalties. These are the penalties that can be imposed for non-timely Medicare reporting. Brendon's going to talk a good bit about that. This is really important right now. The final rule for penalties just went into effect on October 11th. We all need to know about this. That's why we put this as number one. Very important. If we had to list them in order of priority, this should be definitely at your attention. We're also going to talk about, for those of you that work with workers' compensation claims, the new reporting requirement of reporting MSAs via Section 111, which is coming in April of 2025. We're also going to talk about hot off the press. Just last week, CMS released their 2024 submission statistics. I think they'll be very interesting for you all to hear what submissions of MSAs looked like in this year. And very interestingly, and Brendon's going to speak to it, submissions went down since 2024 to 2023. Actually, there were more submissions in 2023. So of course, we predict there's more adoption of non-submits out there, but we'll talk about that later. I'm not going to get ahead of myself. We're just going to introduce briefly. Brendon's going to run through some of our different MSA product offerings here at Sanderson Firm and what differentiates them and how you could settle those claims efficiently and at a reasonable cost utilizing these MSA products. Also, we're going to discuss Medicare's recent policy discussions regarding potentially not reviewing Zero-WCMSAs anymore. Brendon's going to speak to that a little bit later. And then lastly, we're going to talk about the new administration that's coming in January, what that administration's priorities are and how that might impact Medicare secondary payer. Of course, certainly just, a prediction of what that might look like. And then we just want to briefly talk about MSPCollege, which is the educational arm of Sanderson Firm with 2 different designations in MSP. So Brendon, tell us about the very important civil money penalties and what we need to know for 2025.
So we can't, of course, talk about 2024 and 2025 without addressing the most significant thing to happen in 2024, which is CMPs. So when we talk about CMPs, What we're talking about first is Section 111 reporting. So what Section 111 reporting is, for those who may not be aware, Section 111 reporting is a term that refers to Section 111 of the Medicare, Medicaid, and S-CHIP Extension Act of 2007. And essentially what this is, or what this requires, it requires non-group health plans responsible reporting entities to report claims involving Medicare beneficiaries to the federal government. So if you are an RRE, responsible reporting entity, and you're either self-insured or you're an insurance carrier, and you have a workers' compensation claim, a no-fault claim, or a general liability claim, Medicare wants to know about those claims that you have with those, if those claims involve Medicare beneficiaries. So if you have a settlement, Medicare wants to know. If you have a settlement, Medicare wants to know the amount, when it was settled, is the claim accepted, is it denied, what are the ICD injury codes that are related to the claim. And Medicare wants to know all of this information so that they can coordinate benefits for the injured Medicare beneficiary. So interestingly, this has been on the books for over a decade now. To date, there has never been an instance where a responsible reporting entity has been penalized from the federal government for non-compliant reporting. However, when we go to the next slide, we see that CMPs are now live. So last year, 2023, October, Medicare published a final rule where Medicare said, hey, everyone in the industry, look out. We're coming out with civil money penalties if your claims aren't reported correctly. And we, Medicare, are going to make this effective as of October 11th of 2024. So today forward, civil money penalties apply if you're not reporting correctly. So CMS has said that civil money penalties will be imposed in two scenarios. Scenario one is untimely reporting of TPOC. So untimely reporting of total payment obligation to the claimant. That effectively means a settlement amount. So if you have a claim, a work comp claim, let's say, involving a Medicare beneficiary, and it settles, and you don't timely report that TPOC or that settlement to Medicare through Section 111 reporting within 1 year, you will be subject to CMPs if CMS randomly selects that record during its random audit. So scenario one is TPOC. The only other scenario is timely reporting of ORM. So ORM stands for ongoing responsibility for medicals. So if you have a claim involving a Medicare beneficiary, if you report ORM as yes, that means you are accepting responsibility for the claim and you're agreeing to pay for this Medicare beneficiary's future medical care. Conversely, if you report ORM as no, that means you're not accepting responsibility for that claim. And I should backtrack a little bit. It's actually untimely reporting of the acceptance of ORM. That could land you with potential CMP exposure. So those scenarios are all about timeliness, and Medicare has outlined different tiers. So depending on how late you are in reporting the TPOC or the acceptance of the ORM will determine how severely CMS penalizes you for noncompliance. So on the right-hand side, we see three tiers. Tier one is if it takes you longer than 1 year to report the TPOC or the ORM, but you reported at least within 2 years, there is a daily penalty for each day of noncompliance. There's a daily penalty of $250. If it takes you longer than 2 years to report, but at least you report within 3 years, there's a daily penalty, it doubles, there's a daily penalty of $500. And then worst case scenario, if it takes you longer than 3 years to report the TPOC or the ORM, so you reported after, let's say you reported in 5 years, the daily penalty is going to be $1,000 per day. CMS has capped this amount, or the total amount, at $365,000 total. However, this does not count for inflation. So when you factor in inflation into the total exposure, that $365,000 is actually somewhere around about $500,000. So CMS has ran a study on this. They said if we, or they, CMS, would have had civil money penalties in 2022, they would have recovered almost basically $130 million in civil money penalties for non-compliant reporting. So these are some very serious numbers. So we're going to get into an example here because there's so many different dates and numbers and tiers. It doesn't make sense fully. So an example is always helpful just to kind of break this down. So in this example, right, we're talking about civil money penalties and how it could be assessed in a scenario where an RRE is not compliant or does not report timely. So example, an RRE, responsible reporting entity's record, is randomly selected for a CMS quarterly audit. So as a little bit of background, each quarter, CMS is going to randomly select 250 records. So let's say in this quarter, out of 250 records, this RRE's record gets selected. And on this record, the RRE settled a general liability case involving a Medicare beneficiary on January 1, 2025. So that's a settlement. We know that means that's a TPOC, and that TPOC should be reported. However, the RRE in this example doesn't report the TPOC until February 1st of 2026, so over a year later. So what we know from the final rule that's in effect today is the record should have been reported no later than January 1st of 2026, right? Because there's a 1-year grace period, and after that, the CMPs kick in. So in this example, the RRE would be subject to a CMP for the period between January 1st, 2026 and February 1st, 2026, because it's that 1-year grace period. Once you're at a year and a day, the CMP tiers start ticking up, and that's when they actually start accruing. So in this example, because it took them longer than a year, but thankfully less than 2 years, they're stuck in tier 1. So that their daily penalty would be $250 per day for each day of noncompliance. And in this example, they didn't comply for 30 days. So we multiply that out. And in this case, this RRE, functionally how it would work is this RRE would receive an informal notice, formal letter from Medicare identifying the noncompliant record. And it would list the amount of $7,500 as the potential CMP amount. So this is just an example of what a nominal CMP could look like. But when we hop to the next slide, you'll see that things get pretty crazy pretty quickly. And so the question is, do double civil money penalties apply? So stated differently, is it possible for a responsible reporting entity to have 2 civil money penalties assessed against it for just 1 Medicare beneficiary record? And the answer, surprisingly, is yes. So let's say you have a claimant named John Johnson, and John Johnson's a Medicare beneficiary, and he had an accepted work comp claim, and it settled. So you have John Johnson's TPOC record, and you have John Johnson's ORM acceptance record. Since CMS defines each of these as a separate record, it's possible during CMS's audit, though not statistically likely, but it's possible that when CMS digs into the pool, it's not selecting John Johnson, it's selecting John Johnson ORM, and also selects John Johnson TPOC. So if we move to this example, we can see how expensive this looks like. So the bottom of your screen, let's say an RRE settles an accepted workers' compensation claim with a Medicare beneficiary. And this RRE, unfortunately, they mess up and they just completely, they whiff it. They don't report the TPOC and they don't report the ORM. It takes them 4 years to report both of these. So they're in the worst tier, they're in tier 3. CMS may randomly select both the ORM record and the TPOC record for this very same Medicare beneficiary. When we do the 365 times 2, the total CMP amount is $730,000. But once we apply interest, the actual amount is somewhere around $1.2 million. So this is definitely a wake-up call for RREs, because if you're an RRE and you're reporting claims, generally you don't have 2, 3, 4 claims involving Medicare beneficiaries. You've got hundreds or you've got thousands. And so you could be compliant on 99.9% of everything that you report to the government. But if you mess up once and you just fail to report 1 record that happens to have a TPOC and an ORM and you're selected, that's $1 million in damages. So this is very, very serious exposure here. So best practices on how to avoid CMPs. So obviously, number 1, you want to report ORM, the acceptance of ORM and TPOC timely as soon as possible. You have a 1-year grace period, but if there's no real reason to wait a year, don't wait a year. You have the data, go ahead and report it as soon as possible. Don't risk chance. If you are self-reporting Section 111 data to the government, maybe consider having some sort of internal fail-safe, maybe a flag in your system that says, hey, in your system, you populated that it settled on this date. Maybe after 180 days, there's a little reminder, an alert that pops up in your box that says, hey, it's been 185 days. Sure, it hasn't been a year yet, but maybe you want to consider reporting this. If you're not self-reporting, say you're using a vendor, some other vendor, to do your reporting for you as your Section 111 reporting agent, consider using a more consultative reporting agent. So we at Sanderson Firm, we of course act as reporting agents for our clients. It's not enough for us to go to our client and say, hey, look, we tried to report your data, it got kicked back, let's fix it, right? The conversation doesn't stop there. The conversation is, hey, we found this error, let's discuss more. Maybe this is a systemic issue. So we want to prevent that issue and also issues that could occur in the future stemming from that systemic problem. Because we may have saved a CMP, one CMP, there could be potential CMPs on the back end because the actual root issue wasn't addressed. And just remember too that if your reporting agent misreports or messes up, that falls back on you as the RRE. Medicare holds the RRE exclusively, strictly liable. So you can't go back and point and say, hey, it's not our fault, send the civil money penalty to our reporting agent. CMS isn't going to do that. The bill's going to be directly to your doorstep. Also, consider obtaining an objective third-party Section 111 data audit to identify weak spots in your reporting or your data. At Sanderson Firm, we offer Section 111 data audit reports all the time, whether it's a potential client who maybe they have serious concerns about the integrity of their Section 111 reporting data, and they're concerned about CMPs. We can do a deep dive into that. Or maybe you don't have serious concerns and treat it like a checkup, like a doctor or a dentist. You say, look, we think our vendor is doing okay, but can you just double check, make sure everything's okay? We can do that as well, and we've done that in the past. So consider an audit. And then this question does come up from time to time. Should responsible reporting entities report older claims which were never reported? So let's say you have a claim from 2016 involving a Medicare beneficiary, and you never reported the ORM and you never reported the TPOC. The question is, should you report that? Our response is, as attorneys, is yes, absolutely. We're never not going to tell you not to follow the law. So sure, you may say, hey, CMPs don't apply to this claim because it wasn't settled on or after October 11th of 2024. But just, one, the law is law, and two, perhaps probably even more importantly, just remember that we talk about data, we talk about compliance, all this stuff there's an individual attached at the end of this stream, right? It's the Medicare beneficiary. So if you have data that's not reported or is maybe worse, just misreported, that interferes with the Medicare beneficiary's Medicare benefits. So that person could go for treatment and Medicare could deny benefits, and that person just loses their coverage over something that they essentially had no control over. So you definitely want to report older claims even though CMPs don't apply. And then very lastly, some may say, okay, well, let's say it's a settlement after October 11th of 2024. We can just get around Medicare's civil money penalties by just never reporting the claim at all. That's incorrect. Medicare's statute of limitations actually is never triggered until the claim is reported. So if you have a claim, let's say next year, TPOC, a settlement that occurs next year involving a Medicare beneficiary, and let's say you don't report the claim until 2075. During that whole time, Medicare, you're not skirting Medicare's interest. Medicare can still seek recovery after that is reported. So definitely report.
Absolutely. And just to kind of reinforce one of the things that Brendon mentioned as far as, responsibility for CMPs, in talking with, folks in the insurance industry, clients or, prospect clients, I hear a lot of complacency in just expecting that your reporting agent is doing their job correctly and is actually, auditing your data or looking at your data or looking for anomalies, or hear a lot of entities out there relying upon their TPA for their reporting, which there's nothing wrong with that, but just remember that a TPA is not, a specialist in Medicare reporting. There's a lot that goes into this. There's a constant compliance updates issued from Medicare. And so I think the one thing we just want to impress upon you all is to not have a sense of complacency, because as Brendon mentioned, if you're lodged with a CMP and ultimately the error lied with your TPA or your reporting agent, CMS still has the right of recovery of CMPs against the actual RRE. So, and again, just one other thing I just want to kind of give for an example purpose with regard to Section 111 audits and why they're so valuable. We've seen for some of the clients that we've done audits for, some clients that we believe to be very knowledgeable in Medicare compliance, and they've been surprised at some of the things that we found. We audited one self-insured entity, and they had never reported TPOCs on their workers' compensation claims. They didn't know that TPOCs were a reporting requirement as part of work comp claims. They thought they were only for liability claims. Wow, can you imagine that we had not caught this until after CMP started? They could be hit so badly. So I just want to impress upon you that, like, to us, penalties are the most important MSP initiative right now. Make sure your program is ready. things are ready to go. And this is a great segue into what I want to talk about next, which is WCMSA reporting. And again, this is something that if you're using a reporting agent or a TPA, now is the time, if you haven't already, to call them up if they have not reached out to you yet, and to ask them if they're going to be ready for this new reporting requirement. So Medicare announced earlier this year, or it was, I think, at the end of last year, that they were thinking about collecting MSA information as part of the Section 11 reporting requirement. And it's interesting, I had a little itch on my head and I'm scratching my head, and I'm still kind of actually literally and figuratively still scratching my head at Medicare coming up with this new requirement. It especially didn't make sense that all of a sudden Medicare wanted all types of MSAs reported, whether it's an MSA that's already been submitted and approved by CMS, or whether it was a non-submit MSA. So we're thinking, if they've already approved an MSA, why does a work comp payer now need to report the MSA amount again through the Section 111 process? So we learned from Medicare that essentially the whole point behind this new MSA reporting requirement going into the Section 111 process was for Medicare to gain greater visibility into MSA situations, whether it's submitted. And the reason they want it reported is because they told us that after an MSA was approved, a lot of times they would not hear back from the workers' compensation payer and submitter as to whether the claim settled and whether the parties funded the CMS approved MSA. So it's a way for them to close the information gap. And then also, obviously, non-submit MSAs are not pushed through the CMS voluntary process. So Medicare wanted to know about it. So, beginning April 4th of 2025, all RREs that report workers' compensation claims, and this is applicable to work comp only, must report WCMSA information involving Medicare beneficiaries. Even if there was no MSA, you got to populate something. So let's talk about this. I want to make sure it's clear that it does not matter if the MSA was already submitted to CMS for review. I just mentioned that Medicare still wants the submitted MSAs reported through the Section 111 process come April, because they're not ever sure, even after they approve an MSA, whether it was funded amount. They also, because you have to report all workers' compensation claims with Medicare beneficiaries if the settlement amount is over $750. So you're going to have to report MSA information on claims below $25,000, even if it's zero, right? And we'll talk about that in a moment, because you still want to consider potentially needing an MSA on settlements below $25,000 if there's future medical care needed. But again, this information is going to be required. Even if you have denied ORM on some of the injuries, you still have to report this information. Even if the claim is fully denied, you still have to report this MSA information. And also, even if you have a zero MSA and you're able to obtain a statement from the injured Medicare beneficiary's treating physician that no future care is needed, you still need to report MSA information, even if it's zero. We're going to go through the fields on what Medicare is requiring in a moment, but you must always report MSA information on these work comp claims with Medicare beneficiaries that are reportable come April 4th, 2025. So here's a lovely chart here laying out the 7 new data fields that are going to be required to be reported. So it's the MSA amounts, the MSA period. So how many years is this person expected to live? How long is this MSA spanning over in the course of years? Let Medicare know whether the MSA is going to be funded via a lump sum or an annuity. If it's an annuity, it's a structured MSA. Medicare wants to know the initial deposit amount, the anniversary amount that's deposited annually into the MSA account. If it's a submitted MSA, we need the case control number submitted, as well as the professional administrator EIN if there is a professional administrator. So one thing I want to be clear about, you'll see at the bottom of your screen here, if you do not report this as part of your TPOC, you don't report these 7 data fields, what's going to happen? Let's say you just leave these fields blank. Go to report a TPOC, you leave all these fields blank. What's going to happen then is Medicare is going to respond with a hard error. A hard error means it's like the record was never submitted in the first place, which means it's like you've never reported it, which now you're in CMP world, as Brendon was discussing previously, and you could be subject to penalties. So really important that you always fill out these fields, even if the amount is none and zero. And also really important that you talk with your reporting agent or TPA if you're not doing this internally. Has your reporting agent added these 7 data fields to their reporting spec, and are they going to be ready for this come April? It may seem simple, 7 data fields, but I'm sure many of you on the webinar today work for big corporations and know how an IT project list can be very large And even though this could cause penalties to an organization, it might have got lost in the shuffle. Really important that this is prioritized though, right? Because significant penalties are at stake. So definitely want to make sure that you're getting this reported come April. What Medicare is going to do with this data, they're going to take the MSA record that is submitted through the Section 111, and they're going to post it to the Medicare beneficiaries common working file. And the whole point is so Medicare knows there's an MSA available. So if Medicare now receives a bill for something that's related to the work comp injury, and Medicare knows there's an MSA available to pay for that work comp injury, Medicare should be denying payment and saying the MSA needs to pay for it. It's all intended for a coordination of benefits purpose. Once Medicare receives notification via the Section 11 process of an MSA, Medicare said they are going to send notice to the Medicare beneficiary saying, hey, we've received notice of your Medicare set-aside. Just be advised, here are the steps as far as reporting to us how you've spent your MSA funds annually. So I think this will be new for Medicare beneficiaries, and they're going to hopefully understand how to properly account for their expenses to submit an annual accounting to Medicare. And in-process MSAs, those where settlement has not been reported, will be updated to reflect that the MSA has been completed. Points to keep in mind, this only applies to Medicare beneficiary TPOCs, right? Because Section 111 reporting only applies to current Medicare beneficiaries. So if you're doing an MSA for someone that is not currently on Medicare, maybe they're on SSDI or they're 62 and a half years of age or older, which it's appropriate to do an MSA in those situations, and that's great. You should continue to do that, but you won't be able to report that if the person does not become Medicare eligible at the time you settle that claim. This only applies to work comp. This does not apply to liability and no-fault cases. Medicare is not attacking non-submit evidence-based MSAs. They recognize them, and they recognize them numerous times throughout their webinar when they talked about this. They similarly just was submitted and non-submitted, just want to know that the MSA is there so that they can properly coordinate benefits. And also it's important to know that Medicare is serious, or at least they've indicated they are quite serious, that if false information is provided to them through the Section 11 process about MSAs, that they may pursue False Claims Act litigation, which can result in triple damages. They mentioned this during a webinar. We were kind of like, wow, okay, Medicare is letting us know they're serious about this. So make sure that you're properly reporting this information come April. Let us know if you have any questions or if we can assist with that. And again, if you're funding MSAs correctly, the upcoming reporting requirements should not change your current process. And the reason is because if you're doing things correctly, you're properly addressing Medicare's interests, then you really should not change what you're doing. Medicare, again, is not trying to attack non-submit MSAs. But again, if you're not sure about your processes right now and when you utilize MSAs in your settlements, then now is the time to look at it, because Medicare will have this data. But also, I alluded to this earlier, under threshold situations, right? So let's say you have a $20,000 settlement with a Medicare beneficiary, and that person does require future medical care. While Medicare would not approve or review that MSA through their voluntary review process because the settlement is lower than $25,000, you're still going to have to populate MSA information. So those are the situations where you should really be thinking, twice about whether you're not providing an MSA because it's under Medicare's arbitrary review thresholds. If that person needs future care, there should be an MSA there, even if it's minimal. And that way you're not showing zeros across the books on all these under threshold settlements that you're disregarding Medicare's interest. So something to look at. And again, Medicare's review thresholds for review of MSAs have never been a safe harbor. Medicare has said that multiple times. It's just a workload review threshold. So you really ideally need to think about Medicare's interest in all settlements, and also think about what picture you're presenting to Medicare come April of 2025 when these fields are going through. And again, as I mentioned earlier, just check with your reporting agent, make sure they're ready to go, make sure this is ready to go, because again, failure to report this information could result in penalties due to the fact that not reporting this information results in a rejection of the record. Brendon, tell us about the MSA statistics that were released just last week. I'm not sure if you all got a chance to catch our blog that we released last week during a holiday week. It was a sort of a Thanksgiving surprise. What do you think, Brendon?
Yeah, so let's dig into this hot off the press information that was released by CMS, I think less than 2 weeks ago at this point. So at the end of the year, CMS releases data for all work comp MSAs that were submitted to it during that calendar year. So we have back from 2020 to as recently as this year, and this year isn't even over yet. So major, you can see the tons of boxes there, but major takeaways from this is, number one, just the volume of MSAs that are being submitted to CMS each year. What we were seeing was, and kind of still seeing it actually, is a trend In 2020, there were 16,000 MSAs submitted. In 2021, there were 14,000 MSAs submitted to CMS. 2022, it goes down lower to 13,000. We saw a rebound in 2023 last year, where there were more MSAs submitted to CMS than in previous years. But then this year, it seems like it's trending toward another year of a downtrend. So this would mark essentially the fourth year out of the last 5 years that CMS has reviewed less MSAs than it did in the year prior. So the industry is definitely becoming more and more comfortable with not submitting MSAs to CMS, which is of course totally fine and allowed under the law. So number one is volume. Number two is just the total MSA amounts approved. So for this year, if you prepared or obtained a Medicare set-aside and submitted that Medicare set-aside to CMS, the average amount of that allocation was $71,000. However, CMS's average approval amount was $85,000, basically $86,000. So if you submit, what this says is, if you submitted an allocation to CMS and CMS disagreed with the allocation, CMS was counter-hiring, that is rejecting that amount and requiring employers and carriers to fund an allocation that was 21% higher than the amount that was submitted. So again, this marks the second year in a row where if CMS issues a counter-hire, it's at more than 20% than what the parties were preparing for. So that can, of course, really throw off a settlement. Now, 20%, 21%, 22% may seem like, peanuts. But again, going back to my example in reporting, if you're an entity that does volume MSAs, hundreds of MSAs, thousands of MSAs per year, like some of our clients do, 20% at the end of a year run adds up to millions of dollars. So huge takeaways there. If we hop to I believe the next slide. So, okay, perfect. So obviously, most of our clients aren't pleased to hear these 20% counter-hire statistics. Thankfully, at Sanderson Firm, we have products, a different variety of products, which we'll actually cover here today, which can address this concern that we have and that our clients have about CMS forcing carriers to fund more than what they had originally anticipated. So the first option deals with maybe you just, you have a Medicare set aside and you just decide you don't want to submit that allocation to CMS at all. Totally fine. Lots of our clients do that. We have a product called the IMSA, Indemnified Medicare Set Aside, and this is an evidence-based allocation that is never submitted to the government for review and approval. Some of you may say, hey, wasn't there that thing 3 years ago where CMS wrote some piece of policy in their guidance where they called into question non-submit evidence-based MSAs? The answer is yes, but what some may not know is CMS actually updated that guidance. And so after CMS sort of called into question non-submit MSAs, within a few months, Medicare said, hey, look, we backtracked. We are okay with these non-submit evidence-based MSAs, so long as the evidence-based MSA is obviously prepared appropriately and is funded appropriately. So that's the benefit of our IMSA, or the benefit of our IMSA is if for whatever reason CMS a couple years down the line says, hey, look, we disagree with this allocated amount, we will actually step in and indemnify all the parties for the full amount of the exposure under the law. So all parties are protected under our IMSA program. And really any case where we could have prepared a regular traditional MSA on, we also can prepare an IMSA on as well. Differentiators of our IMSA, there are lots of entities out there which claim to have a product that is the same as ours, but I can tell you this sincerely, our product is unique in the space. So we will prepare an indemnified Medicare set-aside on any file. So for example, we'll prepare an IMSA for any injury type. So it doesn't matter if it's a simple ankle sprain where the MSA is several $100s. It doesn't matter if it's a catastrophic injury. And maybe the MSA amount is millions of dollars. We've indemnified or do indemnify files that are in the millions. So we won't, we won't say something like, hey, this is a catastrophic claim. We won't provide indemnification. Secondly, our indemnification extends to all parties. There are some entities out there who only indemnify certain parties, maybe just the claimant and their attorney. We indemnify everyone, claimant's attorney, our client, co-defendants, anyone and everyone. Also, there's no extra fee for our indemnification. So some entities charge a couple $1,000s in order to receive the benefit of their indemnification. We have full faith in our product. And so we're not going to nickel and dime and charge clients for our indemnification when we know that the allocation was prepared appropriately in the first place. We also don't have a professional administration requirement. So you can take the Medicare set aside and the individual, the claimant, can self-administer the funds if they want to. And we won't revoke indemnification on that basis. We also don't have a requirement for the injured claimant to be represented by an attorney. Doesn't matter if they're pro se, doesn't matter if they're repped. We will agree to indemnify. And then also lastly, too, out of the mini litany of things, we also aren't going to force you to go ahead and settle quickly. There is no requirement that you settle your claim within 4 months of the IMSA in order for us to provide indemnification. So you don't have to worry about that as well. So that's our IMSA. We also have our EMSA. Our EMSA is similarly an evidence-based Medicare set-aside allocation. And this is actually designed to be submitted to CMS. So we prepare an MSA using evidence-based medicine, and according to CMS and its own guidance in the WCMSA reference guide, CMS says that, quote, the WCRC, that's the Workers' Compensation Review Contractor, relies on evidence-based guidelines as resources in determining future treatment. So we are simply following Medicare's guidance, preparing evidence-based medicine allocation, and submitting it to CMS. When we do this, when we submit an EMSA to Medicare, we give our clients two numbers. We give our clients the evidence-based number, and we give our client the non-evidence-based number. So the non-evidence-based number, we call it the standard projection amount. This is the amount that we would have submitted to CMS if we weren't submitting and hadn't submitted the evidence-based number. That way our client goes in knowing, hey, look, we're submitting it for the evidence-based amount, but CMS could potentially return a determination of the non-evidence-based amount. So advantages of the EMSA, it can be submitted to CMS. There are cost savings. So on average, it's a great stat. Cost savings from a standard work comp MSA. So if you choose an EMSA and submit that rather than a standard traditional MSA, our clients are saving on average 68% across the board. Huge savings there. Offers transparency because we're giving you both numbers. And then lastly, the biggest note too, the second biggest note is CMS is approving either the evidence-based number or they're approving an amount that's at or lower than the non-evidence-based number. So we have some examples here of what this looks like on these slides, in this slide here. So example number one, we prepared an EMSA for a client at $76,000. That was the evidence-based number. We also told our client, hey, just so you know, the non-evidence-based number is $105,000. So again, we submitted 76. CMS said, great, we agree with 76,000. CMS approved that amount, 28% savings for our client. And example number two, we prepared an evidence-based amount of 126,000, a non-evidence-based amount of 264,000. And CMS said, okay, you know, we disagree with this evidence-based number, but we also disagree with this non-evidence. Well, we also are not going to force you to fund this non-evidence-based number. CMS actually approved an amount of $206,000 because CMS isn't actually seeing the non-evidence-based number. We only submit the one. CMS approved an amount which resulted in a $57,000 savings to our client, so 22% savings overall. Then in the last example, $13,000 evidence-based MSA, $95,000 non-submit MSA or non-evidence-based MSA. CMS issued a determination amount of $23,000, saved our client tons of money there. So really, there is no downside with the EMSA. Anytime you're submitting an allocation to CMS, there is really no downfall in submitting an aggressive evidence-based Medicare set-aside. And then very lastly here, just the last allocation type before we dive into broader 2024 or 2025 topics is our legal compromise MSA. In the interest of time, I'll kind of cover this quickly, but essentially if you have a work comp claim and let's say it's fully denied and you can't gain any traction, your position of course is it's fully denied. There shouldn't be a Medicare set aside at all. It should be zero. Maybe the applicant or applicant's attorney refuses to settle unless there's something set aside for future medicals. That's where our legal compromise comes in. We prepare an allocation, we reduce the allocation amount to account for based on factors that are unique to that settlement, and we reach a compromise MSA number, which is sufficient, almost always sufficient for the parties to agree to settle that fully denied claim. And it has the benefit of our indemnification as well. Okay, so CMS policy on zeros. So I think we're all mostly familiar with what Zero-MSAs are, but generally speaking, of course, a Zero-MSA is an allocation that doesn't allocate anything for future medicals, right? It's just zero. They're common in two scenarios. One is a medical zero. So maybe you have the claimant's treating physician signing a statement saying that this individual doesn't need any future medical care. They're fully healed, right? That's example one. Maybe example two, that there's a legal zero. Maybe there's a legal basis for why there shouldn't be something set aside for future medicals. We see this a lot in statute of limitations cases, for example. Let's say there is a legitimate claim, the person is actually injured, but let's say they wait 30 years to file their workers' compensation claim. Well, under the law, they've waited too long. And so sure, they're injured, but the employer and the carrier isn't responsible for funding an MSA because the claimant waited too long to file their work comp claim. So zero MSAs overall. So CMS, of course, is very stringent and very picky on files that they decide should actually be $0. The industry was experiencing a trend where it used to be sufficient to where if you had medicals confirming that the individual didn't need future medical care and you had a clean payment history, or essentially the employer, the carrier isn't paying for this person's medical care because the claim is denied, generally that was sufficient for CMS to approve a $0 MSA proposal. However, CMS is appearing to make a pretty wild shift. So I was at an event a few months ago where a CMS representative, I won't say who it was, but a CMS director went on the record at this event and said, I wrote it down because this is crazy. He said, quote, it is the existence of a settlement not to has primary payer responsibility that drives a workers' compensation MSA. Liability is not a consideration. So does that make sense for everyone? So CMS is saying that it's the existence of the settlement that drives an MSA. So what CMS is saying to us is, if you have a claim involving a Medicare beneficiary that settles for, let's say, $100,000, CMS is saying, okay, we don't care that this claim is fully denied. Just because it settles, there has to be something set aside for future medical. So CMS is saying that they apparently will not approve a $0 MSA if that $0 proposal is submitted to them. That doesn't quite make sense to me. If you're asking me, I don't think that's supported by law. There is a older case about a decade old out of Texas called Dara. That case involved a conditional payment issue, but you can analogize that to MSAs. But essentially in that case, a federal court held that this Texas employer carrier wasn't responsible for reimbursing Medicare conditional payments because that same primary payer wasn't responsible for the workers' compensation claim under Texas workers' comp law. So if we have, let's say we have a Texas claim, fully denied, zero MSA, maybe Texas is a bad example since they have open meds, but let's say we have a Florida claim, it's fully denied, settling for $100,000. CMS is saying that, the carrier should be funding something for future medicals. Well, what if there's a Florida statute that says, hey, this carrier isn't responsible for this reason? So I could see a federal court saying, hey, under this state work comp law, if the primary payer isn't responsible for reimbursing Medicare conditional payments, then how can the primary payer be responsible for funding this person's future medical care when they were never responsible for this claim under state law, right? That's a very easy argument to make, and I could very easily see CMS being challenged if their position on this holds. So best practices, right? Let's say you want a $0 MSA in 2025. Things to keep in mind, unfortunately, now you have to recognize that CMS's approval of a $0 MSA is no longer a guarantee. Even if you have a signed court order, Heather and I have seen instances where there's been a court order signed by a judge saying there should be nothing set aside for future medicals, while technically saying that this person doesn't require any future medical care. And CMS has actually just kind of played judge and say, look, we disagree with court order. So recognize that could happen. If you do decide to submit and roll the dice, at a minimum, you want to make sure that the medical records and the payment history actually support a $0 MSA. Another option, you can decline to submit your $0 allocation to CMS. Another thing that I found, or that was uncovered at the conference, is the same individual who made the comment on denied claims also said that CMS was looking at entirely removing, eliminating $0 MSA submissions in the future. So in the near future, it could be, if you have a $0 MSA, you want to submit that to CMS. CMS could just altogether say, look, as a matter of policy, we're not reviewing $0 MSAs anymore. And based on the tone and how that was presented, people will interpret it differently. My thought process was CMS could very well stop reviewing $0 MSAs in the very near future. So that's something to keep in mind.
Yeah, it's something to watch. A number of years ago, Medicare was also considering not reviewing $0 MSAs. Now that we're hearing them talk about this again. So I think, certainly if this does come to fruition this time in 2025, Medicare will obviously put out some sort of notice or update their WCMSA reference guide. So stay tuned for that. Just briefly before we take questions, I just want to kind of highlight, obviously we have a new administration in place, a Republican administration with a very highly Republican controlled Congress, and there is going to be certainly probably more of a focus for newly elected President Trump on immigration, tariffs and trade and energy. But he has selected a new U.S. Secretary of Health and Human Services, RFK. He's been nominated for the upcoming term, and the administrator for CMS is Dr. Oz, right? We all know him from TV, so it'll be interesting to see. What I think I want to highlight as far as MSP goes, as far as any impact with the new administration, is the fact that Trump's administration, the Republican administration, has always been largely in favor of more privatization of Medicare, right? So we all know there's traditional Medicare Part A and B, which is promulgated by the federal government. And then there's Medicare Advantage plans, which are private Medicare plans. It's also known as Medicare Part C, like Aetna, Humana, right? And then Part D, prescription drug plans, which are also administered by private plans. The Republican administration has been pushing more toward the privatization of Medicare for a number of reasons. So, and we've seen in Medicare's Advantage plan premiums when Trump was previously president, the MAP premiums dropped by 30%. And then also, generally the premiums are more reasonable, and it's been a vocal part of their policy. So I think we will continue to see Medicare beneficiaries continue to opt more into Medicare Advantage plans over the next 4 years. And this was already a trend. Even during the Biden administration, more and more Medicare beneficiaries are going for Medicare Advantage plans over time. We have, I think it's close to 60% or around 55% of the Medicare population currently enrolled in a MAP plan. So what this really means, for Medicare Secondary Payer is keep in mind those Medicare beneficiaries that you have that are enrolled in Medicare Advantage plans. Keep in mind that the vast majority of Medicare beneficiaries are now opting for that versus traditional Medicare. So that means that you need to probably make sure that the Medicare Advantage plan conditional payments are addressed and taken care of, because the Medicare Advantage plans do have that priority right to double damages, just like traditional Medicare. But again, we'll see. I think, Trump has said that he wants to lower prescription drug pricing. We'll see if this comes to pass. He also has said he's not going to cut one penny from Medicare during his campaign. Dr. Oz said during his Senate run previously that we can expand Medicare Advantage plans, and they're popular among seniors, providing quality care and keeping incentive costs low. And may want to make private Medicare plans the default option rather than automatically enrolling people into Medicare Part A, kind of forcing people into these private plans is something that may happen. But again, it's something to watch, and just, again, concisely from an MSP perspective, just really keep a close eye on what type of Medicare your Medicare Advantage plans that your person has before you settle out that claim, and know that when you're going to traditional Medicare, the BCRC or the CRC to get conditional payment amounts, that those are not the final amounts, and they're not inclusive of Medicare Advantage plan amounts, because the Medicare Advantage plans do their own conditional payment recoveries themselves, or they use subrogation agents. So something to keep in mind. So I'm going to now just cover the MSPCollege, which is, we released this starting in February of this year. We started our first certification through MSPCollege, Medicare Secondary Payer Accreditation. It's comprised of 9 courses discussing MSP principles, everything across MSAs, conditional payments, mandatory insurer reporting. It can be taken fully virtual at your own pace. And so it's great in that regard. So you can take it as quickly or take as much time as you want with the program. Grateful to Brendon, who assisted me as assistant dean in putting this program together. We have had great success as far as the feedback on the program and number of registrants. I believe we're in just 6 or so months, we have nearly 100 students come through the program. We are committed to continuing this program, continuing to put out continuing education. So if you have an interest in the program, please let us know. We do think it's one of the greatest comprehensive overview programs on MSP right now. You get the MSPA credentials after your name. You get a nice certificate, and we will provide the address for that as well. And then just a month or two ago, I think it was in October, we released our second certification through MSPCollege, and it's called the Medicare Secondary Payer. The Medicare Set Aside Certified Planner, or MSACP for short. This is designed to only focus in on Medicare set-asides. It has 11 approximately 1-hour courses, focusing on MSAs. You will be equipped to develop and write an MSA, as well as understand how to submit an MSA to CMS for review and approval, if that's something you're interested in. We felt that the industry badly needed this. There was really no certification speaking to this exactly. We just launched this program, and similar to MSPA, it's fully virtual, can be taken at your own pace, and is going to teach you how to write an MSA and submit it to CMS. So certainly valuable. You can find all of those courses at MSPCollege.com. And again, feel free to reach out if you have any questions on either of those programs. And again, just a little bit about Sanderson Firm. We are a full service nationwide MSP vendor, providing everything from Medicare set-asides to conditional payments, Section 111 reporting, guidance, and audits, as well as MSP legal services. I do want to make sure that you all have mine and Brendon's email address and our office phone number. If you have any questions following this webinar, if we can assist you with anything in the future. We will be continuing our Sanderson Firm webinars in 2025, so look out for those. If you're not already subscribed to our blog, please make sure to do so. You can do that on our website at sandersoncomp.com and receive regular MSP updates as they arise, as well as be notified of future webinars. Thank you all for attending today. We hope this was useful to you. Please feel free to reach out if you have any questions at any time. We will be providing a copy of the presentation to those that attended, as well as the recording. Thank you so much, and wishing everyone a great rest of your 2024 and wonderful holiday season. Thank you. Bye-bye.
Thanks, everyone. Happy New Year.